following program is classified G. It's suitable for all ages.
Tonight, we take a look at the legal instruments governing the conduct of international trade and enterprise, especially between parties that are not domestic. The recent international incident regarding the foreign commercial flight that occurred on Sri Lankan soil has brought a grey area in the Sri Lankan legal system into the limelight. At a time when Sri Lanka is in dire economic situations, where international relations takes a crucial role in assisting to create a better life for all Sri Lankans, such decisions trickle down into areas which would put Sri Lanka on the back foot. How will similar situations be dealt with in the future? And what are the provisions for international actors to gain relief through the courts in Sri Lanka? Good evening and welcome to Law, Land and Liberty, where we are keeping with our promise of bringing in a contemporary legal motion and discussing it, breaking it down in the midst of an expert. And the discussion today is going to be on something that happened within the past week, an issue that one would say has been sorted as of now, but a number of legal questions have come up within the public for quite a number of genuine reasons, and we're going to really break down and see what these reasons are and what exactly was the context to this incident. And what I'm talking about is the, one would say, dispute that occurred. We are not going to get into the case details too much, but the dispute that occurred when it came to the detention of an aeroplane here in the Bandaranaike International Airport. Now, the question most people are asking is whether or not this was an issue that was relevant to Sri Lanka at all, and whether it was something that was to do with two other nations, and how did it end up in Sri Lankan courts. And we're going to try and dwell deeper into that specific issue. And to do that, we have with us a very special guest, to us because he is actually a lecturer of mine, President's Counsel, Seevali, Amithirigala. Thank you so much, sir, for joining us again.
Thank you very much for having me back. It's nice to be back. Thank you.
A very important topic today, sir, and yeah, we'll have a long discussion on it. I can't give the entire description of Sir Seevali Amithirigala. It'll take a very long time, so I'm going to go with a lecturer in laws. He's been
I'm perfectly fine with that.
He's been a teacher for quite some time, and I'm sure a lot of his students must be watching as of now as well. So generally how we conduct this program is we break down the topic, but given that this topic has a lot of variables, a lot of externalities when it comes to not only the legal aspect, but rather the political and the social consequences of what exactly happened, we'll have to talk a bit about those aspects also, which might go out of the certain periphery we generally do. So our first segment, we're going to discuss a bit about the roles related to aviation and how both internationally and domestically those legal instruments have been applied and been sent forward. Secondly, we are going to talk a bit about the international contracts and the jurisdiction that governs when it comes to things like leases and whatnot, when it comes to basic bilateral relationships when it comes to enterprise. And finally, we are going to talk a bit about the consequences of this on a foreign policy level, on the historic relationship that existed between our country and multiple other countries, and how we are going to proceed forward in these scenarios. All right, let's get into the discussion straight away. Once again, sir, thank you so much for joining us.
My pleasure.
So before I get into anything technical, before I give any sort of form of direction to this discussion, what was the main takeaway for you during the past week for this specific incident? Let's not get into too many technicalities, but what was the main takeaway?
I think for me, I had to look at it from the perspective of a lawyer. First and foremost, there was a court order made by a court which had jurisdiction to make that order. And if anybody was not satisfied with this order, they would have proceeded to the higher court of appeal and dealt with the process that is laid down in dealing in a situation like that. That is, of course, the judicial process. On the other, I understand the concerns the government had. The government was dealing with a great friend of Sri Lanka. And I must also say many people were blaming the government, but I did not see any reason why you should blame the government, because the government did exactly what it should do, because the government didn't interfere in the judicial process, which no government should do. And the court delivered an order, and as it happened, The second defendant was represented by the Honorable Attorney General later on, I believe on the 3rd, and submissions were made. And after submissions were made, the court made order, as a result of which this aircraft left the Sri Lankan airport. So what I see is, on one hand, there is a judicial order and the government behaved perfectly fine without interfering with any of the judicial activities. And thereafter, the government also has indulged in repairing whatever that had happened there. So that would be my take on this issue.
So let's get into the legal aspects of this now. Since our first segment, we just want to dedicate a bit about it so that we have the sort of the lattice work set up on the legal instruments in play for aviation in particular. Now, Admiralty law is something that is not too alien to most of us because we are aware of ships and the kind of the laws that govern that. When it comes to this aspects, when it comes to things like detention, where should we look at? Because when I was doing my background research on this, the things like the Civil Aviation Act comes into play. So where do we look at in terms of sources for this?
I think let me start on saying that, you know, the mobility of the populace in the world has led to an international aviation structure, structure, as I said, which would regulate the mobility of people or the movement of people from one country to the other. And may I say, the most important two international instruments that regulate this would be the Montreal Convention of 1999 and also the Warsaw Convention, where Sri Lanka is a party to both. But as you know, just because we are signatories to a particular convention, that convention does not become part of our law unless we bring it to an act of parliament. So whatever that happens within Sri Lanka relating to aviation is governed by the Civil Aviation Act number 14 of 2000, and that happens to be our substantive law which deals with this sort of issue. The answer to the second question is, you know that Sri Lanka has a territorial sea, and above the territorial sea we have a airspace which has Sri Lankan jurisdiction. And that jurisdiction can also be seen as from the point of view of either Admiralty jurisdiction, which involves ships, and in such situations the arrest, the detention of ships and aircrafts would be with a court which has Admiralty jurisdiction, and that is the Commercial High Court of Colombo, which is vested with that jurisdiction, and they have the power to do it. Although I have seen in the media commentaries being made that it is the Director General of the Aviation Authority that has the power, but I must say that power of execution might be his, but the decision would lie in the High Court, because the High Court does have the power to do so.
Right. I think that's a very important clarification, sir, that you mentioned in a very concise manner, because a lot of people...
the Director General will have powers, and the court should have powers also to deal with it, because if the court does not have that power, the court will be basically using a legal word, functus, when it comes to regulating this kind of activity. The purpose the court is being given that jurisdiction is to deal with it. So that is my take on it.
Yeah. So before we proceed there, I just want to make a small clarification here. I don't know if I'm deviating too much from our topic, but I think there was a 19th century sort of decision, R versus Anderson, where they mention a ship is like an island that is of the flag state, that is carries the flag state. So when it comes to airplanes, is it different? The domestic law is what is applicable in those scenarios?
I believe it can have several situations. For example, the flag state jurisdiction is something that is being established by certain conventions as well, because we have flag states which the ship is registered in, and also where the aircrafts are registered. At the same time, you have instances where the international jurisdiction, which is of universality, which is, let's say, a crime that falls under universality jurisdiction, is committed in any one of those. Yeah. So in such situations, jurisdiction will depend on the circumstances and, as I say, the facts of the case also. But you're right. The flag state in certain instances does have jurisdiction to deal with it, yes. At the same time, you can get permission from the countries to which you are going, which says that, we will give you safe passage and we will give whatever we could. And that, as you say, would come within the agreements that they would, bilateral agreements that they would agree and enter between nation states.
I hope I'm not being too hypocritical, sir, by visiting the case this many times, but I just have to make one more clarification, or maybe like it'll connect well with our discussion as well.
Yes.
Now, the Civil Aviation Act.
Yes.
Procedurally, you said that's the substantive law that we are looking at when it comes to issues related to this. What would you say are the salient features when it comes to maybe not bilateral, how would I say it, two other states? So maybe in this scenario, when there is a dispute within two other states, is it encompassed under the Civil Aviation Act, or should we look at it in a broader way?
I think the dispute in this particular case arose as a result of an agreement that these two entities had. And if you look at an agreement, there might be a governing law and a governing forum where the dispute should have been, whether it's arbitration or after that litigation. It all depends on how the instrument is constructed by the parties at the time of entering into the agreement. But if you talk about the Aviation Act number 14 of 2000, that regulates the aviation activities in Sri Lanka in a regulatory format. And the court is taking cognizance of the act in dealing with people who are violating any offense under that or any matter that comes under that, which the court will have jurisdiction. So I would think it is a form of regulating the aviation activities and the industry in the country, that particular act. So to me, the salient feature is to ensure that there is safety of not only the passengers, the equipment, apparatus, and also the aircrafts that are coming in. At the same time, you might have instances where we had just passed the COVID. We have quarantine regulations and all these other regulations, which will also be ancillary or coming under certain instances in aviation. I'm not particularly spacing my discussion or concentrating on the act alone. I think aviation on the whole is something that flows beyond the act, because it is actually the transitional mode or the channel through which people will be basically moving from one country to the other. So it is somewhat the regulation of the industry. I hope I answered your question.
Yes, I think definitely. So you can choose, maybe as a last question for this segment, you can choose maybe not to answer this question also. I just want to...
Let me try and see.
Let me, just to clarify now, there was a big discussion about the fiscal officer's behavior in this scenario.
Yes.
Let's leaving the entire case aside. When a judge, if I'm not mistaken, a judgment is given and for the operation of that to happen, that certain communication should happen, and that would be the role of the fiscal officer. If you could elaborate on that, just to give our viewers a clarification of what the role of a fiscal officer is.
There's a lot of controversy on this issue, and there are lots of charges being made in the press and by people in the industry also about this situation. Well, a fiscal is there to go and enforce orders. The fiscal's rights, duties, and functions are clearly spelled out in the law, procedural as well as substantive in certain instances. And the fiscal is an officer of court who goes and performs the activities of the court. So the efficiency of the fiscal is the one that is discussed in this case more highlighted. But I think all fiscal officers should be efficient, because if you do that, perhaps we can have a better system. So I would like to say this. If there had been any inappropriate conduct, then I think that needs to be investigated. Merely because a person has performed it so quickly, that does not by itself says it's inappropriate. But if there is, there you are. Let me also add another point. I saw to my own eyes and heard to my ears in the media that certain lawyers also had gone with the fiscal. My humble opinion is that the fiscal should function independently. Yeah. We lawyers have a role to play, and I think we lawyers should play our role that we are confined to. We are officers of the court too, so we should perform our task, and I think there's a limitation of what we can do for the client and what we cannot do for the client, and that would not take the profession into a dispute, or if I may say disrepute also. True. So that's my take on that.
I think that's very well put, sir. We'll take a very short break. You're watching Law, Line and Liberty. Stay with us. Welcome back to Law, Line and Liberty. We are in conversation with President's Counsel, Seevali, Amithirigala. So I think the first segment really shed a lot of light on the case, and I don't want to put you in too much trouble.
Can I just add something I missed? I forgot to mention the fact that there is also the 1991 Admiralty Act, and also there are also, 1983 Admiralty Act and the 1991 Admiralty Rules, by which also the Admiralty activities are governed. So that's something that I wanted to add from the last segment. Right.
That makes sense. So within this segment, we want to really touch on the contractual issue that was in place. I think we touched on it a bit during the previous scenario. Just to give some context to the discussion, it was as in allegedly, or I'm not too sure, it's the non-payment of the lease for those specific aircrafts that were taken from an Irish company, yes, which resulted in that case being filed here so that we would detain it on their behalf, if I'm not mistaken. Right. How a similar scenario, so if you just remove these factors, put it as A, B and C, how does that work?
I'll rather put it this way, without going into the facts of the case, because it's a matter before consideration before the court. Let's take a scenario in instances. For example, most of the activities in the world are governed by contracts. And when contracts are made between the parties, generally they don't like litigation very much. So there's always a way to prevent litigation. So one of the features that you will see in this contract is an arbitration clause. If there is an issue, they will go into arbitration and they will arbitrate, and then dispute be settled. The last resort would be going to court, because contracts by nature are not very much prone to litigation, unless, as I said, the last resort, because even in litigation they will decide on which law, and also the forum, because the governing law clause will decide which law would govern, and they will choose a law that favors the investors. So obviously there's a greater leeway for parties to enter into contracts based on their free will, which is also called the freedom of contract. But the issue is when contracts are violated and they are being seek to be enforced in a court of a third country, the third country would perform its activity within the judicial activities of that country. This is like a scenario. But when the court does something of that nature, there is also possibility, I'm just saying a possibility, that it can hurt international relations. Because international relations or foreign relations is generally done by the executive branch of government. And the judiciary is the judicial branch which adjudicates, interprets the law. So these are two different functions, and one should not be overlapping the other. So executive also cannot interfere with the judicial activity, and the judicial activity should be independent. So what is important is to let the judicial activities go. At the same time, the executive must ensure to maintain and to repair the damages that might cause at these junctures. Because I think the duty of any foreign ministry is to maintain relations. It's not only starting relations, maintaining. I think when you come to the next segment, I will be dealing with that more extensively, because any relationship is very difficult to be built. It's even difficult to maintain the relationship. And, this is the reason. So contracts by nature would regulate a commercial relationship. And it is commercial by all means. And they will litigate for getting whatever term that has been violated being enforced, etc. Understandable. But in the process, like what happened in Sri Lanka, hypothetically I can say that a third country could get involved in this in the adjudication, and in the process this sort of situation can happen. So I think these are all curable issues. They are not incurable. They can be cured, and I think governments must do exactly what needs to be done to cure it. So agreements would be important in regulating trade and commercial relations between entities. But trade and commerce can, in certain instances, have impact on foreign relations. And in having those, the art of conducting good relations is to balance the both. This is the important aspect. So what we see is, just because relationships we have, we can't stop contracts. There are millions of contracts made between parties because this is what parties, entities or businesses do. And they will want to enforce any warranty, condition or an intermediate term of a contract in a court of law if the arbitration fails or otherwise. So these are acceptable positions. One cannot go and criticize the court and find fault with the court. These are matters of commercial nature and they will come to court. You can't blame the lawyers who filed it. You can't blame the judge who deliberated. This is not the way to go about it. A judiciary must be independent. And if the judge had made any error, then there is a court of appeal to have a look at it. The press or otherwise or other people of the country is unable to adjudicate upon judicial functions of a judge. It's unacceptable. And I think it's also contempt if you really proceed to do that, because any respectable state will have an independent judiciary. And I'm very happy in this instance that the government of Sri Lanka did not get involved in the judicial activity. And I think, let me add, the Honorable Minister of Justice clearly explained the situation in the press, and I wholeheartedly agree with him, because I think what happened was a judicial activity and only the Honorable Attorney General had the capacity to make certain applications before the court, and as a result of that we've seen the situation where the plane was allowed to leave. So I think all these activities, if I may say both or even more, should function at the same time.
So I think that clarifies sort of the roles, I would guess, for the executive and the courts in this scenario. Before we take another break, and then we'll really dive quite deeper into the foreign relations aspect. If I were to ask you, so is there some maybe salient or some main sort of legislature that governs? Because Russia has been quite clear that they are not willing to go to international courts, and in this scenario, we'll leave that aside again. If that is the case, if there are countries that have those kind of issues, will it have to be dealt with in domestic courts, or is that a grey area?
Answering your question, I don't know whether I can answer it to your satisfaction, but may I say this? This never involved the Sri Lankan government, so Russia is right. This never involved the Sri Lankan government. It was not the Sri Lankan government who sort of had a litigation issue. So if it was a country that was doing it, by all means another country will be affected and they would take it. So Russia is quite right. And I think these matters have to be sorted out diplomatically.
Right. I think that's a very good segue to our last segment, so where we'll talk a bit about the diplomatic aspect, the bilateral relationships and the historic relationship that we've had between nations and why that comes into play. You're watching Law, Land and Liberty. Stay with us. Welcome back to Law, Line and Liberty. We are in conversation with President's Counsel Seevali Amithirigala. So I think I speak to most of my colleagues when I say one of our favorite parts of our lectures with you was when you explained sort of the history and the foreign relations aspect of many things because of the subjects that we were studying, and that is how it was grounded in reality to most of us. And this segment, I think, feeds into that aspect really well. Russia is a country, again, as we discussed, over 65 years of diplomatic relationships. Leaving aside this case, I think this is where the legal and the social aspects would now coincide. It's a country that grants, to this day, scholarships to students in our here. It's a huge, as now with the economic situation, we are looking to Russia again. Is it the sort of damsel in distress kind of scenario that we are looking at, or is it something deeper than that?
I have a different take on this. Before I come into that answer, can I just say this? In international law, generally the traditional view was that if a state was owning an aircraft or a vessel, let's say a long time ago, sovereigns were queens, kings, regents, princesses. So the state was synonymous with them. State was the queen, the king. So all these vessels, aircrafts were in the name of the sovereign. So under the doctrine of sovereign immunity, you couldn't assert jurisdiction. But that absolute principle of jurisdiction has now been restrictive. In other words, they have changed into what is called the restrictive theory, where if an aircraft or a vessel is indulging in a commercial activity, there will be no immunity. So it is for all purposes a commercial activity that they perform. Now, one thing that happened in the past is we were able to maintain foreign relations better because we didn't have embarrassing situations. After the restrictive theory, we have situations where, state, whatever that would emanate from the top of the state can still be subject to seizure, would be subject to imprisonment or whatever enforcement that another country would do if it's a commercial act. This is where we are today. Now, Russia understands that, and we understand that. I would like to say this also. You just mentioned the number of years we've been having relationships. Everything bottles down to a relationship based on trust. Sri Lanka has had a position she has occupied as a very friendly nation to powerful nation states. For example, Russia, China, India, and we've had some countries where we've had some sort of a spiritual sovereignty like the Royal Kingdom of Thailand. We've been a great friend to many of these countries. And the strength lies in our people. We are a group of people who've been respected, loved by these powerful countries. So as much as we are in a situation which is now a dollar crisis, which is, last time I had a look at the media, I saw a very responsible lady from a lending institution, an international lending institution, said that the Sri Lankan crisis is mismanaged. I agree with that. It has been completely and utterly mismanaged by the governments that was there before, and also the present government that is in power. And people are protesting. They want the president to leave office. These are matters that the government themselves has created. Nobody can blame other than ourselves and our governments for creating this sort of situation. Now, we are in distress because of our own problems. But I like to say this. They've been our friends not only when we were distressed. They were our friends when we were really flourishing. So they will continue to be our friends if we do not exert them unnecessary. Any friend will be worn out if you go and ask money from that friend. Your relationship, the flavor of the relationship will change. And I hope our governments will understand this. So we have been living beyond what we have been earning as a nation state. And now we are looking into our friends for assistance. All that is good. But it's important to have that ethic in ourselves if we are looking to our friends to be good friends, because we have to be responsible in this relationship. So, as you said, Russia has been having relations from 1956 up until now. The Right Honorable SWRD Bandaranaike was the Prime Minister of Sri Lanka. He was the Prime Minister under whose tenure this relationship began, and it was actually strengthened by each and every president, each and every prime minister of this republic. I say that with responsibility. It doesn't matter which party came to power, Russia was our friend. But you know, we've had very important milestones in our relationship, and I like to go to 1963. The Lady Prime Minister, Madam Bandaranaike, visited on a state visit to Moscow, and you could see even on the YouTubes today, all photographs or the telecast that goes on, and how well our Prime Minister was received by the Kremlin at the time. And after, I believe, 46, if I'm not mistaken, 43 years, we had a high-level visit again of His Excellency the President Maithripala Sirisena in the year 2017 to Russia. And that was also a very important visit. So you could see Sri Lanka has had her position with Russia in the highest levels of state relationships. And I think we should maintain, the underlining theme is that we have to always see that we maintain that relationship in a position of strength. This is up to our people. I think our people understand it, and I hope our politicians understand this better, because as if I may put it, it is the politicians who usually upset this soup. So I think it's very important that the politicians become more responsible, our fiscal policies are tightened, and our governments act more responsibly, because our friends are not to be blamed when they are not assisting us in a need. Not that they are not assisting us. They want us to put our house in order. So that is a good friend, and a friend indeed. Because, you know, a friend in need is not necessarily a friend who is trying to, you know, give you everything when you're in need, because you created that scenario. I think the Sri Lankan view must be to move ahead, to forge relationship with responsibility. And I think, may I say, although I have said about the mismanagement of the economy, may I say in this situation, I welcome, as I said earlier, the initiatives by the Honorable Minister of Justice, who immediately took upon himself to meet the Russian envoy. I also would like to take the position to say some of the opposition MPs, the opposition parties have. The Venerable Omalpe Sopita visited the Russian envoy with a delegation of priests. I welcome that. The Right Honorable Vimal Veeravansa, Member of Parliament, has echoed it. I welcome that. The Right Honorable Leader of the Opposition has mentioned how important Russia is. This shows that the friendship with Russia is a common relationship that we all want to cherish. And I think also for our benefit, the Russian Foreign Office also notified us that, you know, they appreciate how well it was done. So just to recap on what I said, it's not only Russia, it's with any other nation state. Because, you know, even if you take personally, as a person, you would be worn out by a friend who always wants you to help him, you know, from your pocket money, for him to do whatever he wants to do, which he can't afford. So we have to not be that friend, you know. It's Sri Lanka has been always responsible, so let's be responsible. We have been a very respectable nation state. The evidence is very clear, no, Russia still respects us, and we do respect Russia, and we have issues of the international community where we will deal with it diplomatically.
So I wanted to ask this question last, but I thought of bringing it now so that you have time to respond,
yes,
because it's a bit of a sensitive issue now. Today, we cannot talk about Russia without talking about the Ukraine issue. And every country, specifically the West, is pushing almost all states to take a position on the Ukraine issue, which is which according to me doesn't seem too fair, but that is sort of the narrative that has been pushed. We saw the imagery of the former Prime Minister of Pakistan, Imran Khan, who was in Russia the day it happened, and he had a different take on it, but he also mentioned that he was not aware, and that is not the kind of image that they wanted to project. Now, in this scenario, are we, by our silence or maybe by our attribution to the fact that we agree with, or our compliance with the nation of Russia, are we saying okay, or are we taking a position there? Or I know I'm moving a lot away from the legal aspect of everything, but we can't really neglect that issue because that is partially one of the reasons why this came up in the first place. What are your thoughts on that, sir?
You have your private thoughts on matters. And if you're a person who represents this republic, you have an official stance. Privately, of course, it's a violation of human rights, and you would privately feel that, human rights violations should not exist. Officially, Russia is one of our friends. We should be very cautious when we make comments in world politics and in world affairs on behalf of the Sri Lankan nation. And age-old two words that we use is no comment. And I think we have to also maintain those two words as appropriately also maintain and use it, because to continue with our relationships with countries that have assisted us. Can I give you another example? We are predominantly a nation where Buddhists live, no?
Yeah.
But the Dalai Lama is not going to come to Sri Lanka because we would not offer a visa to the Dalai Lama to come in here, because China is a good friend of Sri Lanka.
Yeah.
So we, in good relationships, we have to make certain sacrifices. And those sacrifices might not be the most reasonable ones for many, but it is the most reasonable for a nation state. So I believe we have to make our choices. If we are going to make official statements, we have to understand that Russia is a great friend. We don't want to embarrass her. And beside, I think the Ukrainian crisis is spoken about many countries in the world. I believe we can always stay away with our no comment officially, because I believe Russia is a friend of ours. I don't think we should get involved unnecessarily in the discussion of Ukraine, because Russia is a good friend and we don't want to embarrass Russia. And my answer might be received by many of my students with a negativity and say, that's what I said, you can have your private opinion. But if you are an official of this state, I think you should have the official view. That's what is important.
I think that really put into perspective a lot of things. Something that I want to clarify, and something I noted down when we spoke before this program, was you mentioned that when it comes to foreign relations, it should be understood by the book, and we should be street smart, as in book smart and street smart in that scenario.
Absolutely.
What specifically do you think you were trying to mean?
What I was trying to tell you is, we have our own homespun way of dealing with it. You see, it was a phenomenon. The first woman prime minister was produced by this great nation. It was a phenomenon that when she went to Buckingham Palace to meet the Queen. It was a phenomenon when she went to Russia, when she negotiated, when she became the head of the non-aligned movement. Mrs. Bandaranaike, the Right Honourable Madam Bandaranaike, had her flavour in the foreign policy of Sri Lanka, which continues to live despite the demise of the Grand Lady. Not only did Madam Bandaranaike do it, the Right Honourable President Jayawardena had it. The Right Honourable President Jayawardana's visit to the White House, especially the Reagan White House, and the speeches he made, especially when Frank Sinatra was there to entertain, had the flavor that President Jayawardena brought to the relationship of Sri Lankan foreign policy. Let me also say this. President Kumaratunga's era had been an era which had flourishing foreign policy benefits to Sri Lanka. Madam Kumaratunga was not only a product of two prime ministers, she herself knew the art of diplomacy, because she was also assisted by, in my opinion, the best foreign minister Sri Lanka ever had, the Right Honourable, the late Lakshman Kadirgama. So we had lots of countries which came in with Madam Kumaratunga's charisma. And one example is Nelson Mandela and South Africa. I believe, I remember also President Mandela referring to Madam Kumaratunga as his daughter. Because this is the flavor that Madam Kumaratunga brought in to our foreign policy. That's what I say. We have to learn the rules by the book, but we should be street smart to play it accordingly. And I brought some of the personalities in Sri Lanka. The Right Honourable Ranil Wickremesinghe, the present Prime Minister, has had his own ethos, had his own flavor in foreign policy. It's very important. But unfortunately, may I say this also, some of the politicians that we've had very raw, very abrupt styles of dealing with our friends. For example, take our great friendship with Japan. That was at the very highest point during President Jayawardena's time, because President Jayawardena's speech in San Francisco, I believe, and which assisted Japan thereafter, and they were so affectionate to the Sri Lankan community and especially President Jayawardena. And this relationship was, as we all know, we would have read on the press, it was put into difficulty by having certain decisions made with business dealings that were already undertaken between those two nations. So, sometimes politicians must understand it is not they who matter, their style matters. Foreign policy is something different. Foreign relations is something very different. The foreign policy can be performed in the foreign relations by leaders, and our leaders have been remarkable. Although we have a very negative attitude to Sri Lankan politics, go down in history. These leaders brought the best they can to our nation. Don't forget, we are the succeeding generations of these people. So we have to understand, why were we respected so much? Why did they continue to have a relationship when we were such a small country? We still are a small country. Why do they have such respect for us? Because we were important to them. Then what happens now? Are we not so important? In my opinion, it is our governments that have made us not so important, especially in the last 2.5 years, if I may stress, which has brought a tremendous negative economic repercussions to people, as a result of which you can see that there is a lot of public protests and etc. In all fairness to the Excellency who rules us presently, the present President, I must say that even during his era, even during this period of time, foreign relations have flourished. But that flourishing has also been marred by these economic problems that have come across. And I must say that greater emphasis should be put on, and more investment has to be made on this relationship other than merely going and asking for money, because this is not going to give a good example in our foreign policy. We have to put our house right, and we have to really start doing things which we can afford to do, and not getting our friends to be responsible to pay for us. So I think all that would come in. I mean, what I spoke today was what I observed from a street smart point of view, not necessarily from the books, because actually go down the clips, you could see the Sri Lankan sari and a lady in a Sri Lankan Candian sari or a Sri Lankan sari in foreign forums, and it's always somebody who you can reflect and say it's one of ours. If you see somebody wearing the Sri Lankan national, the sarong and the shirt, the national, you could say it is one of us. We've had these instances, we've been in these photographs because we were important. We are important. As a nation, what I want to say is, let's rise up. Once we were great, we can always be that greatness we had, we can always go back to it. You see, we are that group of people.
Right. So I think very, very well put. What towards the end of the discussion, as maybe like our final question, what I want to ask you is, will we have to see certain legal issues rising out? Now we have one would say different parties in Ireland in this scenario who may not have been satisfied with how everything went down. In the future, do you see, because you work with a lot of embassies and you know the context of this, will you have to face something in later days in international courts? Is there some provision for that, or will it be not directly relevant to this scenario at all?
I don't think it is something that we should look so negatively. I mean, I'm not saying you are negative, but to comment negatively. I'm very optimistic about it. It's up to our foreign office to deal with it. Everybody can't be satisfied at the same time. It is up to us to maintain, as I said, this relationship. If the relationship is something that is getting sour, it is important for us to understand, say, look, this is not going to work. Let's see how we can work it through. It's all about discussion, diplomacy, and, coming back into the track of, going together. I don't think disputes are going to be likely, but I think it's important to understand the importance of foreign relations. I don't think we can exist without foreign relations. We can't. No country can. We've passed that era. And even during the Sinhala kings, we've had foreign relations. I mean, most of our queens during the Kandyan kingdom came from the Vijayanagar Empire, came from the Indian kingdoms, and they were also somewhat ambassadors for their nation states that they were bringing. So I think it is something that has to be played, played very carefully. I don't think we would. That's my take on it. As a human being, I can be wrong, but I'm optimistic. Sri Lanka would not be getting involved in these issues unless, of course, we do not reform ourselves. For example, we have a debt crisis, we have a dollar crisis. On those, perhaps we might have legal issues that are coming in. That also, I don't know whether it will proceed to litigation. There might be, other ways of getting us to refinance, and et cetera. So those are also matters that we'll have to think about it. That's why I went on to the economy, because it is the economic activity that is the next challenge that is going to affect our foreign policy, and that I think our foreign policy makers, and especially the government, should be very mindful, because too much of debt from anybody is going to make them not a friend, but somebody who's going to give you money, like a money lender. You know what I mean? Relationship is different. It's the dealing. So let's move away from it. That's I'm harping on that in this discussion, because to me it is the pride of our people. Our people have had this pride throughout. So it's very important to also. It's the pride of being self-sufficient. It's the pride of being, able to do things without being under obligation. That is what I was saying. That would be the biggest challenge in time to come to the foreign policy, more than litigation.
Right. President's Counsel, Seevali, Amithirigala, as always, a very, very insightful conversation. Thank you so much. I think
Thank you very much.
Quite a lot in a very short time.
Actually, I really enjoyed coming back into your show. I must say, I don't think I spoke very much on the law today. I think I spoke mostly on relations, especially international relations, historical anecdotes. It has been my pleasure last time coming in, and thank you so much for inviting me. It's always a pleasure to come to your channel, because your channel is very much concerned about our people. I'm stressing it for the second time in your show.
Thank you
so much. It's not flattery, but it's my honest opinion. Thank you very much.
Once again, President's Counsel, Seevali Amithirigala, lecturer in laws. I mean, a lot of students here would know who is. Thank you, sir, for coming.
My pleasure. My pleasure. Thank you very much.
All right. When dealing with matters related to international affairs, any false move would have disastrous ripple effects, which all of us as citizens should be aware of. Madeleine Albright, former United States Secretary of State, once captured this thought process by stating, "A lot of people think international relations is like a game of chess, but it's not a game of chess, where people sit quietly, thinking out their strategy, taking their time between moves. It's more like a game of billiards, with a bunch of balls clustered together." That is all from us here at Law, Land and Liberty. If you had missed today's program, you can watch the entire episode on our YouTube channel, youtube.com/Derana English. Join us again next week as we break down a contemporary legal topic. I'm Dhanidhi Tanmasa. Have a great night.